Thank you, Cindy. My name is Gail. I'm the director of the Virginia office for the Southern Environmental Law Center. We felt comments, also pulling minutes from the James River Association and Appalachian Voices who filed comments. Appalachian Voices mentions that they have 35 Virginia members who filed comments, so I'm not sure where the discrepancy is between 8 and 35 is, but I have a copy of what Appalachian Voices members filed. I also have copies of our May 11th filed SELC.
They already have it.
Oh, great. The Dan River coal ash spill on February 2nd, 2014 was the product of Duke Energy's criminal actions. Duke has pleaded guilty in federal court to 4 environmental crimes directly related to the Dan River spill. Duke's egregious conduct has to inform what this board demands from the company as we seek to resolve both Virginia State Water Control Law, and also the Virginia Waste Management Act. Now, I know DEQ staff has stated that it believes it has applied the statutory criteria in calculating the penalty here, and obviously we respectfully disagree with that. The statutory criteria cited in section 62.1-44.15 and 10.1-1455 make it clear that each day of a violation constitutes a separate offense, and specify that penalties must be based upon the following factors, which I've grouped into 3 categories of factors. The first category is the severity of the violations and the extent of any potential or actual environmental harm. The second category is the compliance history with the facility or the person involved. And the last category is any economic benefit realized from noncompliance and the ability of the person to pay the penalty. Allow me to touch on each of these 3 categories of statutory criteria. The first one is the severity of the violations and the extent of any harm. 2 days after the spill, the Charlotte Observer reported that the Dan River was, quote, running as thick as gray as concrete. In Danville, a finger stuck in the water, quote, disappeared at the first knuckle. North Carolina's Department of Health and Human Services issued a warning that remained in effect for 5 months until July 2014 to avoid direct contact with coal ash in the river and along the shoreline. North Carolina continues to warn today, quote, that people do not eat any fish or shellfish from the Dan River downstream of the spill in contaminated sections of the river. And there were news outlets that have reported dead clams and mussels for at least 20 miles downstream of the spill. For 3 months after the spill, the cities of Norfolk and Virginia Beach suspended their withdrawals of drinking water from Lake Gaston because of the spill. And as you heard, even today, 92% of coal ash from the spill remains in the river system. That's coal ash containing arsenic, mercury, and lead. Dr. Dennis Lemley, who's a leading expert on coal ash pollution at Wake Forest, has published an assessment in the peer-reviewed journal, Environmental Pollution, that has estimated the impacts of the Dan River spill at more than $295 million. That study is cited in our letter from May 11th. And yet today, Duke Energy and DEQ are proposing a consent order worth only $2.5 million. That's capturing less than 1% of the calculated impact. 1%. I think that tells you a lot about what you need to know in terms of the consent order here failing to address the severity of the violations and the extent of the harm, which is one of the statutory criteria. So let me move on to the next set of statutory criteria, which is the compliance history of the facility. As I mentioned, Duke has pled guilty to 4 environmental crimes related to the Dan River site. Those crimes and the harm that they caused Virginia occurred because Duke Energy ignored years of warnings about the Dan River site. Nearly 30 years ago, back in 1986, Duke received a dam safety report that warned about the shortened lifespan of this pipe, the one that failed here at Dan River. But Duke Energy did nothing about it. In 2007, Duke received another report that identified seepage close to where the pipe was running under the coal ash lagoon, And again, Duke was warned that they should investigate this, that they should do a camera inspection of the pipe because it was a dangerous risk for failure. Again, Duke did nothing about it. In August of 2013, just 6 months before the spill happened, North Carolina state officials filed sworn pleadings in state court in North Carolina stating that the Dan River coal ash lagoons were illegally contaminating the groundwater, and it was posing, quote, this is from the North Carolina officials, a serious danger to the health, safety, and welfare of the people. That's 6 months before the spill, and yet still Duke Energy did nothing about it. So when you think of the compliance history of the facility, which is one of the statutory criteria, we need to remember that Duke committed federal environmental crimes here, that they designed a system and operated a system that was dangerous and ignored years of warnings about that system's potential for failure. That in the few months leading up to the spill, Duke was on notice that it was breaking environmental laws because of the problems at this site, and still, despite 30 years of warnings, Duke did nothing about it. That goes to the compliance history. Let me turn to the third and final category I want to touch on, which is the economic benefit realized from noncompliance and the ability of the person to pay the penalty. That's in the Virginia statute. What Duke has done here, obviously, is illegally and criminally push the cost of managing its coal ash pollution onto downstream Virginia communities that rely on the Dan River for clean drinking water and recreation. And the company obviously made that choice for its own economic benefit. As we've mentioned in our written comments, Duke Energy's CEO in 2014 received total compensation of $8.3 million. Now that's more than 3 times the proposed settlement in this case. And that's a fact that goes directly to the statutory criteria of ability to pay. The company's most recent Form 10-K, which was filed with the Securities and Exchange Commission, lists total assets of the company at more than $120 billion with a B. That is more than 2.5 times the entire budget for the Commonwealth of Virginia, as was approved by the General Assembly in 2015 and signed by the governor. The company is more than 2.5 times the size of the Commonwealth of Virginia total budget. The company can afford to clean up the Dan River. And that's why, with 92% of the coal ash remaining in the river, we're asking this board to reject the proposed consent order and direct the parties to begin working on a $50 million compensation and remediation plan for the communities and the neighborhoods in the affected watershed. Thank you for your time. If I have any remaining time, I'd like to pass it on to Frank Coleman of DARPA and RBA. Thanks.
Thank you.
David Bernard.
Thank you. My name is David Bernard. I'm the Volunteer Water Quality Chair of the Virginia Chapter Sierra Club. The low fine of $2.5 million for the coal combustion byproduct spill caused to Virginia by Duke Energy's willful negligence is a problem. In no way does it equal the damage from the CCB's, coal combustion byproducts, which cannot be removed from the Dan and Roanoke rivers. The damage done to the Danville, South Boston, and Kerr Reservoir communities is irreversible. Punishment for wrongdoing should deter more wrongdoing, and this low fine will not do that. The federal government's $102 million fine for this and other of Duke's wrongful acts serves as a deterrent and balances, to some degree, the damage done from this spill. In 2009, I served on a DEQ panel formed to advise on new regulations for so-called beneficial use of CCBs. Sierra Club's purpose was to help craft rules that would permanently prevent CCBs from leaving their enclosures and contaminating air or water. Though I was disappointed the panel's scope did not extend to other types of CCB disposal, I wish to commend the professional staff of DEQ's Solid Waste Division for draft rules that met most of the common sense guidelines Rick Parrish of SELC and I offered. The real disappointment, however, came when final rulemaking was deferred and then dropped, as both Virginia and federal governments put off meaningful action on the CCB problem for years. Regarding Dan River, a Wake Forest study estimated Dan River spill damage at $295 million. A Virginia fine penalty of upwards of $200 million would be proper and serve as a real deterrent to future spills. Thank you.
Thank you. Appreciate your comments.
Frank Holloman.
Hello, Mr. Chairman and members of the committee. My name is Frank Mullen. I work at the Southern Environmental Law Center, also in North Carolina. But I must add, I once lived in Virginia. We have a son and daughter-in-law here, and we hope to soon have one or more little Hollomans who are native-born Virginians. But I have worked closely with two North Carolina, Virginia organizations, the Dan River Basin Association and the Roanoke River Basin Association, and I'm here to speak to their concerns. First, as my colleague just said, and this is important to emphasize, this is a law enforcement proceeding. This isn't a community chess proceeding about what we might find. This is a proceeding about what is the appropriate penalty for violating Virginia's environmental laws. And there's no dispute that happened. And in fact, there's no dispute that Virginia's environmental laws were violated because Duke Energy committed crimes. Crimes, criminal conduct that they have confessed to. As my colleague said, 2 of these crimes led directly to the spill that violated Virginia's own environmental laws, and it also damaged Virginia's environment. In addition, during the grand jury investigation, the U.S. Department of Justice learned that Duke Energy's own employees had urged it to inspect the very pipe that broke. That would have cost a few $1,000s. And this was recently. Duke's management refused that expenditure. And that is why we are here today. What is the response of the Virginia law enforcement agency to this? A trivial fine to a multi-billion-dollar organization of something over $2 million. Put that in comparison. North Carolina's agency, which by the way is under criminal investigation now, it has proposed a $25 million fine for groundwater contamination at one site that did not have a spill. The federal government imposed a $102 million fine. For Duke Energy, a $2 million penalty for admitted violations of Virginia law, which resulted in a catastrophic event in a Virginia river, resulting from criminal conduct, is insignificant. Perhaps the most disturbing thing I've heard is what I heard earlier today. The head of law enforcement for the Department of Environmental Quality for the state of Virginia referred to the officials of the lawbreaker, Duke Energy, as my colleagues. Now, can you imagine any other law enforcement official doing that? We consider the people who belong to the Dan River Association, the Roanoke River Association, the people of Virginia, and their water resources to be the people who should be considered the colleagues of the law enforcement officials, and the lawbreakers should be deterred from doing this again. That's what we, our children, and let's hope all our grandchildren will get in the future. That's why we ask you to reject this recommendation. Thank you.